Schuster.
So you're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok speech. So why can't we simply look at it as a restriction on ByteDance?
Because I think the burden falls directly on TikTok. And I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over Jeff Bezos' international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to either sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos' First Amendment rights. That would also violate the Washington Post's First Amendment rights, because they are ultimately the one that's suffering the burden under that law, because they have to go dark and close up their book.
You name it. What are the new ones? Blue Sky? I mean, none of these are apparent, right? You get what you get, and you think, that's puzzling. And it's all a little bit of a black box. So you can't just mean it's a black box, it's covert. They're all black boxes. And if you just mean what's covert is the fact that there's China behind it, I mean, honestly, really, like everybody does know now that there's China behind it. So I just don't get what this covert word does for you.
I think the problem with just saying as a general matter, China has this capability and might at some point be able to exercise it and manipulate the platform is it doesn't put anyone on notice of when that influence operation is actually happening, and therefore it doesn't guard against the national security harm from the operation itself.
I think Congress and the President were concerned that China was accessing information about millions of Americans, tens of millions of Americans, including teenagers, people in their 20s, that they would use that information over time to develop spies, to turn people, to blackmail people, people who a generation from now will be working in the FBI or the CIA or in the State Department. Is that not a realistic assessment by Congress and the President of the risks here?
Well, Your Honor, I'm not disputing the risks. I'm disputing the means that they have chosen. One way, the most direct way to address that, all of this user data sits on data servers in Virginia controlled by Oracle. I'm not talking about the National Security Agreement. What I'm talking about is a law that simply says to TikTok Incorporated and its U.S. employees, you cannot share that user data with anybody. You can't give it to ByteDance. You can't give it to China. You can't give it to Google. You can't give it to Amazon. You cannot give it to anybody under threat of massive penalties.
Quotes, and to ensure that the Chinese government has the power to access and control private data that the company holds. So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor, I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and...
Well, just hold a second. Well, as I said, you began by saying this is a U.S. company operating in the United States, and it seems to me that you're ignoring the major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States with its own set of free speech rights.
Do you dispute the fact that ByteDance has ultimate control of TikTok in its corporate organization?
Yes, Your Honor, I do dispute that, but I also don't think that it matters, because even if China could exercise overwhelming power against TikTok versus ByteDance, I don't think it would change the analysis. And
Isn't that a pretty paternalistic point of view? I mean, don't we normally assume that the best remedy for problematic speech is counter speech? And TikTok says it could even live with a disclaimer on its website saying this can be covertly manipulated by China. In case anybody were left in doubt after today about that possibility. So you're saying that won't work because?
That won't work because it is such a generic, generalized disclosure that it wouldn't put anyone reasonably on notice about when it's actually happening. And the example I've been thinking about is—
argument is that the average American won't be able to figure out that the cat feed he's getting on TikTok could be manipulated, even though there's a disclosure saying it could be manipulated.
But imagine if you walked into a store and it had a sign that said 1 of 1 million products in this store causes cancer. That is not going to put you on notice about what product is actually jeopardizing your health. And I think that's roughly equivalent to the type of disclosure they're contemplating here.
General, isn't the whole point of the divestiture requirement that the content on TikTok would be different if it was owned by a different company? I'm still struggling with your insistence that this is content neutral versus content based when we have that kind of circumstance.
The reason that I am continuing to try to hold the line on that is because there is nothing in the Act that would directly dictate any different mix of content on TikTok. The U.S. subsidiary could use the same algorithm, show the same content by the same users in exactly the same order. It's not about trying to interfere with the U.S. subsidiary's exercise of editorial judgment in any relevant sense. Instead, all Congress was doing was homing in on the problems of having a foreign adversary be able to interject itself and be able to harvest the data.
But your friends on the other side say that the motivation for doing that is because the foreign adversary might influence or change the content. So content matters, doesn't it? I
think that content was relevant to Congress's concern about an adversary having control over the communications channel. I think not, again, because of any particular concern about viewpoints or subjects, but just that this would be
Isn't that relevance enough to trigger at least some scrutiny, with a heightened scrutiny from the standpoint of our legal tests?
I certainly understand that intuition, and if the court thought that it were prudent to simply try to rule narrowly here and not dictate broader First Amendment principles, we have no problem with the court assuming that heightened scrutiny applies. We think the law easily satisfies it.
And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the Bezos children hostage, and it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down, because that would violate Bezos's rights and the Washington Post rights.
Grounds, and that answer has to be no.
Congress doesn't care about what's on TikTok. They don't care about the expression. That's shown by the remedy. They're not saying TikTok has to stop. They're saying that the Chinese have to stop controlling